Informed consent many years ago was an honest method of exploring various treatment options with a patient. Next, it became a malpractice shield. This shield morphed into a sword as lawyers sued doctors for giving inadequate warnings. They filed lawsuits when the informed consent didn't perfectly disclose an imperfect outcome. Surgery or treatment outside the consent led to lawsuits for battery against a patient. So, what exactly is the legal definition of informed consent? Informed consent in California is the process by which a patient is provided with sufficient information to make a voluntary and educated decision about their medical treatment. This process involves several key components. First, we look at capacity and voluntariness. In Conte versus Girard orthopedic surgeons, the court found that the patient must have the capacity to reason and make judgments, and the decision must be made voluntarily and without coercion. The Horowitz Law Office is presently prosecuting a case against Dr. Jeffrey Poge and John Muir Hospital in Walnut Creek, where the allegation is that consent was obtained by fraud. This theory was attacked on legal and factual grounds by the defendants who both deny wrongdoing. But they lost the initial challenge to throw out the case, and the court allowed the case to proceed. Physicians are required to make certain minimal disclosures to obtain informed consent. These disclosures include 1. A reasonable explanation of the recommended procedures. 2. The likelihood of success of each recommended procedure. 3. The risks involved in accepting and rejecting each proposed procedure, particularly the potential of death or serious harm and complications that might possibly occur. The physician must always disclose any personal interests that may affect their judgment, even if the doctor is 100% honest and acting in the patient's interest. The case law supports the doctor who has fully and properly disclosed the necessary information. At that point, it is the patient's choice in deciding whether to undergo the recommended treatment. This takes legal responsibility out of the hands of the doctor and leads to the early termination of many medical malpractice lawsuits. For political reasons more than practical reasons, California has actual laws requiring doctors to give specific warnings and information to patients about specific conditions. First up, if you're facing breast cancer, your doctor has to give you a clear written summary of your treatment options. This covers the risks, benefits, and alternatives, so you can make the best decision for your health. This is nice. Everyone is against breast cancer and wants to know every single alternative, but why just breast cancer? Why not nose cancer and eye cancer and skin cancer? Maybe this one makes some sense in that the decision tree for breast cancer, if sloppily given, may very well lead a person to make a choice they later regret. Next, if you need a blood transfusion, you'll get a guide explaining the procedure, its risks, and other options. This helps you understand exactly what's involved before you agree to it. Now, it is hard to imagine a doctor giving you an elective blood transfusion. California's Health and Safety Code requires that doctors who do an annual gynecological exam must provide a standardized summary containing a description of the symptoms and appropriate methods of diagnoses for gynecological cancers. Shouldn't that be part of the exam? Perhaps the idea is that this forced education is beyond what doctors would normally do, so it has a public benefit. The Business and Professions Code requires physicians to provide written information to patients considering silicone implant surgery, and not to leave men out. Doctors, when providing a prostate exam during a physical examination, must provide patients with a standardized summary about the availability of appropriate diagnostic procedures. This video is not the place to make the obvious jokes, but feel free to add your own in the comments section. And here's something else. Doctors must tell patients about the Open Payments Database. As you probably know, this is a federal online tool that shows any financial ties between doctors and drug or medical device companies. So that is today's overview of informed consent. It increasingly a government-controlled and regulated part of medical practice.
If you are a physician facing legal challenges relating to informed consent, the Law Office of Daniel Horowitz can assist you. Call Daniel at 925-283-1863. We are medical law experts and we serve only doctors and never the large medical institutions. Again, if you need a lawyer, we can help you or make an appropriate referral. Call us at 925-283-1863. Thank you for watching our video.